Mm.
Okay, students, this is chapter 3 of the company law, whereby I'm going to discuss constitution of a company with you all. So if we look at section 31 of the Companies Act actually, there is no requirement to have a constitution. This is only optional. So meaning if a company is being formed, there is no constitution, it's okay. Okay? So we can what I've informed you, let's say there is no requirement for to have a company constitution. This can clearly be seen from the following provision of the Companies Act. So the 2016 Companies Act is very different from Companies Act, the previous Companies Act, whereby the previous Companies Act make it compulsory to have a constitution. So under our latest Companies Act, 2016, this is not compulsory. And where is the proof to show that this is not necessary? So if we look under section 14, number 1 I put here, where this shows that there is no need to have a company constitution. Number 1 it says, a company is formed by registration in the registrar of the company. A person desiring to form a company shall apply for incorporation to the registrar. This is under section 14, right? So in nowhere it says that this fellow have to file the constitution on behalf of the company. And number 2, if the registrar is satisfied that the requirement of the Companies Act are complied with, and upon payment of the prescribed fee, then the registrar under section 15 shall enter the particulars of the company in the register, assign a registration number to the company as its company registration number, and issue a notice of registration in the form and manner as the registrar may determine. So nowhere at all says that a constitution is must here. And number 3, once incorporated, a company is said to be formed under section 18, and the notice of registration is a conclusive evidence under section 19, and the company became a separate legal entity from its members and shall have unlimited capacity under section 21. Okay? So nowhere it says that a constitution is compulsory here. It's just that under section 619 subsection 3, it says that if there exists a constitution, then it's being deemed adopted under this Companies Act. So number 5, under section 38, check here, only companies limited by guarantee. Only companies limited by guarantee shall have a constitution. So the other companies, there is no need to have a constitution. Okay, so what is the situation before the Companies Act 2016? So before 2016, Memorandum Article Association, this is the document which is called a constitution, meaning there are two documents here, the memorandum and also the article of association. So, and these are actually constitution. However, these documents actually are the internal documents that provide information as to what the company can or cannot do and how it should do it. Okay, this document, the Memorandum Article of Association, before 2016. And it set out the purpose or objects of which the company is created and the rules to be followed in running it. This includes details of such matters as the capacity, the rights, the power or privileges of the company. This is under section 35, section 1. Okay, so what happened after 2016? So after we have this Companies Act 2016, these both documents, the memorandum and article of association, both documents now is collectively known as the Constitution. So meaning both documents is being combined together. Now we have only one document, as the document is known as the Constitution. So under section 38, section 2, whereby it says here, the company limited by guarantee must state that the company is company limited by guarantee, and also the number of members which the company proposed to be incorporated. So we have discussed what actually is the company limited by guarantee. Under section 33 sub 1, the constitution once adopted, this becomes an agreement actually between the company and its shareholder, and each shareholder, because this is an agreement between the shareholder and the company, between the shareholder and the other shareholder. So they have to follow actually the rules that this constitution creates. On the other hand, the company also owes the same duty to the shareholders, meaning the company also have to follow these rules. So if let's say one of the parties refuse to follow the rules, then actually the other parties can enforce them, can take action lah. Okay? Okay, what is the contents of the constitution? So a company limited by guarantee, as I informed you earlier, must have a constitution. This is being stipulated under section 38 sub 1, and under section 35 sub 1 it requires that the constitution may contain provision relating to the objects of the company. What is the object of the company? This is actually the activity that the company can be involved in. So this is the object of the company. The capacity, rights, powers, privileges of the company. If the provision restricts such capacity, rights, powers or privileges, since Company Act gave unlimited capacity under section 21. Okay? If let's say this, there is a limitation to this. What is capacity of the company? Company can only borrow money up to 1 million. So it's stated that, meaning these powers of the company is being limited by that constitution. Okay, and also other matters contemplated by this act to be included in the constitution. So like company limited by guarantee, it says that you must state how many members, right? So these are other matters whereby the Companies Act wants a company limited by guarantee to include this in. And any other matters as the company wishes to include. So these are other matters. If the company wanted to include other matters which is not provided, so you can, no problem. Okay? So as for company limited by guarantee, from this above, it's mandatory, it's a must that we must state that the company is a company limited by guarantee. So that's why this is what mentioned under II just now. Matters contemplated by this act, meaning these are the matters which the Companies Act said you have to include. For company limited by guarantee must include this. And secondly, the number of members with which the company proposed to be incorporated. So under section 32 sub 2 says here, any provision which contravenes or is inconsistent with the Companies Act, then the provision of the Companies Act actually will prevail. So what is this? These are with regard, actually the Constitution cannot make something which is illegal to become legal. Like office of directors. The Companies Act have clearly said that the office of directors must be determined during the annual general meeting. So the Constitution cannot say something else. Okay, because that is wrong. Okay. Company limited by guarantee are required by section 38.3. So this is actually a repetition, whereby I highlighted to you just now. There are certain matters which need to be specified. Company limited by guarantee, that the company is a company limited by guarantee, the objects of the company, the capacity, rights, powers, and privileges of the company, the number of members with which the company proposed to be incorporated. This is for CLG only, the matters contemplated by this act to be included in the Constitution, and any other matters as the company wishes to include in its Constitution. So under section 38 sub 4, if the Constitution purports to divide the company's undertaking into shares or interest is a provision for all share capital and share reward. This is for CLG, okay? For other companies, okay. For CLG, it seems that they are trying to because CLG, they does not have share capital, right? So if they did this, they are trying to acquire share capital. So that's why it is wrong. So just now, I inform you. In fact, the provision of the Companies Act state that the most important point that needed to be included in the Constitution is the object of the company. So meaning the object clause, because the object clause actually will reveal actually what is the capacity of a company, what can be done and what cannot be done by a company. So this object clause is very important clause in the Constitution, because it states the purpose for which the company is set up, why the company is being set up, and it identifies the business and the activities that the company may engage in, and the extent of the power and the legal capacity of the company. Okay? And company also shall be restricted from carrying on any business or activity that is not within those objects. So it's very important for investors, for shareholders, they wanted to know this. So if let's say there is a constitution, so it's very easily actually for the investors to focus on what actually they want with the company. So this object clause, it may be classified into 3 types. Can be the main object, the dependent object, and also the powers of the company. So when we talk about objects, the main object, the dependent object, what is the main object? This is the activities in which a company is specifically authorized to engage. And this could be considered as the main object. Like UITM. What is our main object? This is education. Okay? So these are the activities specifically authorized to engage to. University Petronas, right? What is the dependent object? This is unspecified. Actually, this is additional activities which a company is authorized to engage in association with one of its main or independent objects. So like University Petronas, what is the main object? Education, right? So what is additional activities? So for education, of course, they can have professors from overseas as professors in their universities. They can have linkages with other industries. So this actually is the dependent objects to ensure that the main object can run smoothly. So they need to have these dependent objects. Then the power. So this object, the main object and the dependent object, this is the rights given to the company. Okay, hak-hak yang dia ada. Okay, whereas the power ni, the kuasa dia, the power of the company. So a company also requires certain powers to enable it to achieve main and dependent objects. You ada hak tapi tak ada kuasa, tak guna kan? Yeah. So that's why you have the rights and of course so you need to have the power to achieve the main and dependent object. Example, power to borrow money, to hire employees, incur debt, open accounts, bring legal action, etc. Okay. So let's say I am a lecturer, right? So I have the power. I'm powerful. I can walk to a student and I can slap the student. I have the power. But do I have the right to do that? I don't have the right to do that. So if I have the right to do that, however, I have power to do that, and I do that, that is wrong. So that is why now we have a lot of cases brought up by parents against teachers. Why? Because these teachers, because they have power, and they did it. However, they are not aware actually they don't have the rights. From where do you get the rights? The right must be given by the law. Okay, and the constitution actually is the internal law actually for the company. So if let's say the company have power, however they does not have the rights, they cannot do it. It's wrong. So you need to have the rights, then only you can actually carry on with the power. So I don't know whether so that you can understand me or not. Yeah, that is the simple example I give you just now. So and this power of the company can be classified into three types. What is? Those which are expressly conferred by the Constitution, those which are implicit and incidental to the attainment of the object, and those implied by laws or acts. So under Section 35 Sub 2B, the Commission has full capacity and powers to achieve such objects unless the Constitution provides otherwise. Okay? So meaning if there is no restriction in the Constitution, then the company actually have the full capacity and have powers to achieve that object. However, if it is being restricted by the Constitution, of course need to follow the Constitution. Under Section 21, companies have unlimited capacity, can exercise all the function of a body corporate and have the full capacity to carry on or undertake any business. This is the provision of the Companies Act. For those companies who does not have Constitution, they can rely on this. However, if what is being done is that, therefore, if what is done is not restricted by the Constitution and the Companies Act, of course, companies have the power to conduct the state transaction. Okay. However, if being restricted by the Constitution or the Companies Act, so meaning the company does not have power to do it. So it is possible to include a general purpose object, okay, to allow the company to engage in business that the members or directors think desirable. So meaning the object need to be no need to be specific, like the case of Bell House Limited with the City Wall Properties Limited, whereby the object clause says that to carry any other trade or business whatsoever which can, in the opinion of the board of directors, be advantageously carried on by the company in connection with or as ancillary to the general business of the company. So now they are giving the discretion to the directors. Okay, as long as ada kena-mengena dengan general business of the company, they can do it. Okay, so this is actually discussed, it has to be valid. Okay. So apart from the object clause, just now we said that the object clause is very important. to know what can be done and cannot be done by the company. So apart from that, it also contains regulation concerning the internal management of a company. So before this, all this is inside the article of association. So now, as I told you earlier, everything is included inside the constitution. So this deals with matters such as issue and transfer of share, appointment and power of directors, procedure for meeting, payment of dividends and secretary. So not all companies must have constitution. Company limited by guarantee, of course, must. It's a must for this kind of company to have constitution. Yeah, example, company limited by share, no need to have constitution. However, if they want to have constitution, of course, go on, go ahead, no problem. So if a company does not have a constitution, no problem, because each directors and each member of the company shall have their rights, powers, duties, and obligations as what is being provided by the Companies Act 2016. So meaning if no constitution, is it a problem? No. Just like the Partnership Act, just refer to the Companies Act. Okay? So apart from what is being laid down by the Companies Act, the company can decide what to include in the Constitution. Okay? So generally, apart from the object clause, which I discussed with you earlier, so the Constitution will cover all this. Before this, all this is inside the article of association. So now, I said now, they have only one document. So all this will be inside the Constitution. What is this? The share capital and the variation of rights, liens, calls on share. Ni orang tak bayar lagi kan? Macam mana nak panggil dia untuk bayar? So all of these, alteration of capital, general meetings and proceedings at general meetings, appointment, powers, duties of directors, procedure for allotment and transfer of shares, how dividends are to be declared, rights and obligation of members, division of powers and the relationship between the general meeting of shareholder and board of directors. If you look here, it says here, how dividends are to be declared. But you have to bear in mind, dividends can only be paid if there is profit. If not, it's actually against the Companies Act. If against Companies Act, cannot, okay? So, if the above is not provided by the Constitution, then no problem, yeah, because we can always refer to the Companies Act 2016. So, what is the doctrine of ultra-virus? Let us have a look in this case of Arab Malaysian Finance Berhad versus Meridian International Credit Corporation Limited. So, in this case of Arab Malaysian Finance Berhad versus Meridian International Credit Corporation Limited, this case involved the issuance of letter of guarantee whereby the court held the issuance of letter of guarantee actually is not ultra-virus. Okay? So, the most interesting what is being held by court in this case is this. It says here, anything ancillary to the carrying out of the primary object of the appellant company must be regarded as powers of the company. It says here, apa-apa pun, anything yang ada kena-mengena lah dengan perjalanan syarikat yang asas tu, okay, have to be regarded as powers of the company, and anything else not ancillary, yang tak ada kena-mengena to the primary object and falling outside the scope must be ignored. So meaning, whatever which is outside the scope, it has nothing to do with the primary object. This is the one which we say to be ultra-virus. Di luar bidang kuasa. You as a company, you cannot do this. This is wrong. Okay? However, as long as it's within the primary object, this is considered as valid. It's not ultra-virus. Okay? So, when a company does something which is not authorized, which falls outside the scope of power defined by the object clause of its constitution, this is the one we said to be ultra-virus. Right? So, under the common law, an act or transaction that was ultra-virus was what and did not bind the company. So, not even the unanimous assent. So, meaning if, let's say, the majority of the shareholder consented to it also, it will not, they cannot ratify. What I'm trying to tell you, they cannot even ratify this kind of contract, and they cannot make it binding on the said company. Okay, it's very different from pre-incorporation contract. Okay, so let us have a look at the case of Ashbury Railway Carriages and Iron Company versus Rishi. So what happened in this case, that the director of that company, they entered into a contract on behalf of the company to purchase concession to construct a railway, although actually it's not within the object clause of the company. Okay? And then the shareholders then later on, they ratified what has been done by the directors. And then later on, the vendors of the concession brought an action against the company because they refused, the company failed to perform their obligation under the contract. However, what the House of Lords held, that this is not within the objects of the company. The contract was ultra-virus, and because of that, the contract is actually void and cannot be ratified. So, okay, whether a certain act is within the powers of the company and is carried out in furtherance of some purpose that is not authorized by Constitution would be ultra-virus. It's within the powers. However, for some purpose that is not authorized by the Constitution. So would it be ultra-virus? And the first view said, yes, it's ultra-virus because what you have the power, however, the purpose is not authorized. So this is ultra-virus. So like what happened in the case of reintroduction. So what happened in the case of reintroduction, the company was formed to provide accommodation and entertainment to tourists. Ini adalah bisnes yang kena mengenai dengan pelancongan. Okay, they to provide accommodation and also entertainment, ya, bagi penempatan dan juga hiburan pada turis. So the object clause, they were formed because for that purpose. That is the purpose why the company is being formed. Then the object clause gave the power to the company to borrow or raise money in such manner as it deemed fit and provided that each of the object was an independent object. And then what happened? The company later on, they switched to pig breeding. So dia tukar bisnes dia kepada menternak kinzih. And they borrowed money from the bank for this pig breeding business, and they gave debenture to the bank as security. And later on, of course, they failed to pay the said loan, and now the question is whether the loan is actually ultra-virus or not. Because we know that the company was formed for tourism, right? So the court held the debenture were void. Why? Because the court held that clause was about a power, not an independent object. It gave power to borrow money. However, it does not give the rights to do this pig breeding. Okay? That the borrowing was ultra-virus. The transaction was entered into for the purpose of a business that was not authorized by the Constitution. The Constitution does not give the right to borrow money for pig breeding. Okay, view number 2. Such an act would not be ultra-virus, meaning it would be valid only if it beyond the capacity of the company, then only it will be considered as ultra-virus. This is similar to our Companies Act section 21(2) and section 55(2)(b. It talks about companies have the capacity to enter into the full capacity to enter into a contract, right? So let's have a look at the case of Christchurch City Corporation versus Flamingo Coffee Lounge Limited. This company, they conducted a textile industry and then it changed its name and applied for a government concession to operate a restaurant at an airport. So let us have a look at the object clause of the said constitution of the company. The object clause says the company is authorized the conduct of textile business and included a power to acquire any government concession if thought desirable. You see the word and, included, dan kena masuk kan? Yeah? So the concluding paragraph of the object clause specified that all its objects were independent. Okay? And later on, the company now, you know that the company now involved in this restaurant business whereby they acquire this government concession to operate this restaurant. Court held this is valid because why? They have the capacity to gain the government concession for the airport restaurant. This activity actually is a valid activity. Why? Because it's being included inside the object clause. Okay? Okay. So, under the common law, what happens if the transaction is ultra-virus? Can the members of the company ratify? Boleh tak disahkan oleh members, maybe during the AGM and so on? The three applications of the doctrine is this. It cannot be ratified, and because of that, it becomes an easy excuse for the company to avoid their legal obligation. So senang-senang aja kan, dia nak larikan diri, syarikat nak larikan diri sebab dia tahu kalau ultra-virus tak payah buat, then they will not be liable. Okay, so they can just, you know, easily try to avoid the obligation under the law. Okay, so as a result, what will happen? The third parties that therefore cannot exercise their right against the company. So actually, the similar situation is applicable in Malaysia. However, in Malaysia, we have Section 39 of the Contract Act. And under Section 39 of the Contract Act, this doctrine of constructive notice says that an outsider, there is no need for an outsider to be informed what is the internal document of the companies. Meaning, for an outsider, they are not aware what is the content of the constitution. And because of that, once they follow whatever is being stated, provided by the Communist Act, then actually what they did actually valid. Okay? So now let me goes on with the doctrine of ultra-virus in Malaysia. Yes, actually we did actually accept this doctrine of ultra-virus in Malaysia. Why? Because under Section 35 sub 2A provide that the company shall be restricted from carrying on any business activity that is not within those objects. So, in other ways, meaning this section, our Communist Act, through this section, we actually accept the doctrine of ultra-virus. Like we said, if it's not within those objects, it shall be restricted. Tak boleh buat lah, sebab tak ada dalam objek clause. Tak boleh buat. Okay? However, the effectiveness of Section 35, subsection 2, subsection 8 is being reduced by Section 32. Why I say it's being reduced by Section 32, subsection 2? Because this section does not allow provision of company's constitution to contravene the Companies Act. Okay? And one Section 31 also gave the companies unlimited capacity to exercise its function as a body corporate. Okay? So the effect of this provision is that if a transaction is clearly against the object of a company or the nature of the company, then only it will be ultra-virus. So, do you remember, students? I informed you once you wanted to form a company under Section 14, you must take down what is the nature of the company. So, let's say the nature of the company is agriculture and suddenly now you are going to do mining. Of course, that is ultra-virus. This is clearly contradicting the nature of the company. And furthermore, yes, it says here, Section 32 sub 2 says, it does not allow provision of company constitution to contravene the Communist Act. Okay? Does it contravene Section 31? Because Section 31 gave a company unlimited capacity to exercise its function as a body corporate, meaning the capacity of a company is of unlimited powers. However, this is only applicable if the part which contravene the Communist Act actually is trying to make something which is legal become legal, then that is not allowed. However, whatever provision in the Constitution which is legal, that is actually allowed. So what I mean is like this. Example is fees of directors. So fees of directors, can the Constitution put inside the Constitution? The fees of directors is to be decided by the board of directors. That is wrong, because according to the Communist Act, it needs to be decided through a general meeting by the shareholder. So if, let's say, the Constitution is trying to evade something which is being provided by the Communist Act, cuba nak larikan diri, cuba nak lari daripada peruntukan akta syarikat, itu yang salah. If not, no. It is still valid. Okay? And we have to bear in mind, for third party, meaning for outsiders which deals with the company, there are no need for them. In Malaysia, there is no need for them to worry about the ultra-virus doctrine once the provision of the Communist Act is being complied with. Because the internal document of the company is not the concern of the third party, because under Section 39, the non-application of doctrine of constructive notice. So meaning outsiders, no need to have notice what is going on with the company. What is the company's document? What is inside that document? That is not their concern. So this doctrine can no longer be used by a company as an excuse to say that a transaction cannot be enforced by or against the company once third party complied with the Communist Act. So meaning the situation is different from the situation in England. In England, if you wanted to deal with the company, you need to go through the constitution of the companies. Because if something is ultra-virus, then the company can try to evade their obligation under the law. So, okay, this issue of ultra-virus, it can only be raised against the company and not against the third party. So, this is clearly elaborated in the case of Ashbury Development Company Limited versus Landmark Finance Limited. So, what happened in this case? This Ashbury, he is the sole shareholder of Landmark Finance. And now, he sought the declaration that there are two debentures which this landmark finance granted to United Dominion. He said that these debentures are actually ultra-virus. Okay? Because why? Because now United Dominion is trying to enforce the debenture. United Dominion sekarang menuntut hak mereka di bawah debenture. Right? So, the court agreed that debentures were ultra-virus. However, the applicant, the applicant here, Hawkesbury, okay, they should seek relief from the company. Kenapa tuntut kepada United Dominion, Union Dominion? Why actually he claim from Union Dominion? He should claim from Landmark Finance. The application fail. Yalah, kenapa agaknya dia tak tuntut daripada Landmark Finance? Because Landmark Finance actually his company, right? Why? Because he is the sole shareholder. So if this is the case in Malaysia, so we can exercise the lifting of the will. Remember, you see? Trying to involve in fraud trading. So this is wrong. It's in Malaysia. That is the situation in Malaysia. So he cannot just try to run away from his obligation by saying that this is ultra-virus. If this is in Malaysia situation. So in the case of Pameran Holdings yang Berhad, the plaintiff and the defendant, they enter into a written sale and purchase agreement of share, and then the defendant failed to pay purchase price. Dah beli saham tak nak bayar. So when he don't want to pay for the purchase price, now plaintiff applied for summary judgment, tuntutlah terhadap dia sebab tak nak bayar harga saham. Dan the defendant claim that the transaction ultra-virus. Dia kata tak nak bayar sebab benda tu ultra-virus. Tak valid, right? The defendant claim that. The court held actually, he cannot claim this ultra-virus doctrine. Why? Because he is not the member of the company. Okay? He is not a member of the company. Kenapa dia bukan member? Dia belum lagi beli saham. He did not pay for the said share. Because this ultra-virus doctrine can only be claimed members of the company, debenture holders, or their trustee and the minister. And because of that, the defendant fails in this case. So, yang ini ulang banyak kali lah. Banyak kali saya kata, Ultra-Virus Act or transaction cannot be validated, though it's been ratified by all the members of the company. Cannot. However, foreign company, they are not covered by our Communist Act provision. So, they are covered by the statute where their company is being formed, incorporated. And because of that, a certain provision of the Communist Act will not be applicable to these foreign companies. We have a lot of foreign companies here in Malaysia, right? So what is the legal effect of the Constitution? Okay, so if the company have a Constitution, what is the effect of the Constitution? So the Constitution, when adopted, so the previous Companies Act, so meaning if the company is being formed before 2016, they will have a constitution, and if they did not amend it, then the constitution will still be valid. So what is the effect of the constitution? So the constitution shall be adopted by the company and the members to the same extent as if they respectively had been signed and sealed by each member and contain covenant on the part of each member to observe all provision of the constitution. So meaning as if this is a contract between the members and the members and the company and members, as if they signed the said contract. Okay? So what is the effect of the constitution because of this section? Okay, the fairness, because they have signed the contract, meaning they have consented, right? They have consented to the constitution, and because of that, whether the provision of the constitution, whether the content of the constitution, whether it's fair or whether it's unfair, so it's not relevant. It's not relevant. Why? If you say that it's unfair, why you want to become one of the members of the said company? Okay? Because this is a matter of contractual obligation which has been agreed by all parties. So let us have a look at this case of Wong Kim Fat versus Leong and Communist Land Berhad. So the article of the association, the constitution, provided that any shareholder which holds 7 out of 10 of the issued shares capital of the company have the right to acquire any other shares that they do not hold. So meaning the majority who holds 70% share of the company, they can acquire the share of the minority. And it happened to be that the plaintiff objected to this article. Why he objected? Because the defendant, he holds 250,000 shares out of 300,000 shares. So meaning now he holds more than 70%, right? and he has tried to acquire the shares of the minorities. So that's why the plaintiff as a minority, he objected to this clause. But what the court held? The court held that the fairness or unfairness of an article is not relevant in enforcing the article, since it is a matter of contractual obligation. So saya sebut, sama ada dia adil, tak adil, maka itu bukan persoalannya. So once you become the member of the company, you yang jadi ahli pada cakap itu, you bersetuju. Okay? So in this case, well, by looking at this case, we said that it's very unfair. How can we allow the majority shareholder acquire the share of the minority? Tapi itulah, undang-undang is like that. Okay? So what is the effect? It's not said. The effect, firstly, this is a contract between members. A contract between a member and another member. So each member should observe all the provisions of the Constitution. So this gives every member a personal right to make the other member observe the term of the Constitution. So yes, it's a contract between one member and another member. However, they can only enforce those rights that affect them in their capacity as members, not in some other capacity. So let's have a look at the case of refill. In the case of refill, it stated that, okay, if any member wanted to transfer their share, then they must inform the directors. Then the directors will actually take over the share lah, at the fair value. Refill wanted to transfer his share, but directors refused to purchase them. Okay, so that's why refill now took legal action against the directors, so that the directors will comply with the article of association, and the court held that these provisions were a binding contract between refill and the directors. Okay, that's why we said that this actually is a contract between members. The director is also a member of the said company. And also it's a contract between the company and the members. Let's have a look at the case of Hickman versus Can or Romney Marship Breeders Association. So the article of association in this case provided that if there is a dispute between the association and the members, then the matter should be referred to an arbitration. Kalau ada pertikaian, rujuk kepada timbang tara. Jangan rujuk kepada mahkamah. So then suddenly a dispute arose between Hickman and the association, and he brought the matter to court. Okay? So the association prevented Hickman's case from being heard, relying on the article just now. Yeah? So the association said actually, the article of association said must go to arbitration. Cannot go to court. So court held that article or contract between association and its members, and because of that, this provision to refer to arbitration was binding on Hickman. Okay, so court under that situation cannot hear his case. Kena pergi penimbang tara lah. And the case of Simon Queen versus Exton, also involving members. Okay, contract between members and also the company. This company provides in the article of association in the Constitution that the consent of both Simon and Exton need to be obtained for certain contracts. So meaning if the company wanted to enter into certain contract, they need to have the consent of these both directors. So Simon, there are certain proposal whereby this Simon refused to give his assent. Simon tak nak bagi kebenaran, kan? So this refusal actually is as accordance with the article of association. So in order to overcome Simon's objections, so meaning all the other directors not happy with this, and the members were not happy, so what they did, they passed a resolution now, they allowed that decision of Exton alone. Tak payah Simon pun tak apa, kita gunakan Exton saja. Kita gunakan satu resolusi mengatakan perlu keputusan Exton alone. So now, of course Simon is very angry with this, so he sued the company and the directors to prevent them from acting on the resolution. Apa mahkamah putuskan? What the court held? The court held that company was bound by the article, and the resolution was against the article, and that injunction, satu injunksi, menghalang syarikat tadi meneruskan dengan resolusi itu, ia pun dibenarkan. So tak boleh lah, syarikat tak boleh lah. Kena dapatkan juga kelulusan Salmon dan Exton. Okay. So, a company may enforce the Constitution against members. Members also can do the same thing. Okay? Members also can do the same thing. They can request that companies must also comply with the state constitution. So in Pender versus Washington, the court held that the members have a right to enforce the articles which entitles them to have their votes counted at the general meeting. Yes, this is the right of the members, so that they are allowed to vote and need to be counted, right? So in Woods Odessa Water Works Company, okay, the members were able to make the company to comply with the articles that provided that the company shall pay dividends to the members. And ini adalah permohonan untuk bayar di dividen. Tapi just now, however, I have informed you earlier, student, nak bayar in Malaysia, you wanted to pay dividend, must gain profit first. Then only can pay the dividend. The members can enforce the constitution against the company. However, it can only enforce provision which gave the rights to them as their capacity as member, not in some other capacity. In the case of Eli with a positive government security life insurance, Eli is a solicitor. Eli is seorang peguam. He is a lawyer. He was employed by the company to draft the constitution. So what he did, he added inside the article association, provided that he said he will become the company solicitor. When actually Eli is also a shareholder of the company. And the company actually don't want him to become the company solicitor. So now, Eli is suing the company based on the provision of the constitution. So the court dismissed his suit. Why? Because the court held that he could not rely on the article to give him the right to be the company solicitor. Because that right was conferred in the capacity other than that of a member. Ini dia menuntut hak dia bukan sebagai ahli, menuntut hak dia sendiri sebagai peguam. So cannot lah. Okay? So number 3, the constitution are not a contract between the company and outsiders. Okay? So can outsiders, if let's say there is a provision in the constitution pertaining to an outsiders, can the outsiders enforce the state provision? No. This is clearly in the case of Raffles Hotel Limited versus Main Banking, whereby in the constitution of Raffles Hotel said that it gave the lessor and Malayan Banking power to appoint a director for the company. And then what the Malayan Banking did, Malayan Banking appoint themselves as one of the director. However, the company declared the appointment as invalid. The company don't want Malayan Banking to become their director. God held that since the lessor was not a member, since they are not the member of the company, so they cannot enforce their rights actually to appoint a director of the company. And therefore, that appointment actually is invalid. So dia bukan member, tak bolehlah menguatkuasakan constitution. Yes, the constitution is not a contract, as I told you earlier, between company and outsiders. So if let's say what happens if the company suddenly alter the article, and because of that it affects the relationship that the outsider have with the company. What can be done by the company? Because now the article is being amended. So the outsider cannot stop the company from doing that. And they also cannot enforce their right. So what remedies actually they have under that situation? So, if let's say the effect is that outsider now have lost their right, they can sue the company for breach of contract. However, they cannot stop the alteration. They can claim for other remedies, maybe for damages and so on. Okay? So this is what happened in Southern Foundries. So that's why I said cannot stop the company from doing this, from altering the constitution. So in Southern Foundries, they appointed this Mr. Shaw as their managing director for 10 years. Okay? In the written agreement, there is a written agreement, he is being appointed for 10 years. However, 3 years later, Southern Foundries was taken over by Federated Foundries. Syarikat diambil alih oleh syarikat lain, and the Federated Foundries, what they did, they amended the article of the company so that they can remove the directors of Southern Foundries. So meaning, Shaw is also being removed. Okay? So when they put into effect the altered articles, Shaw now sued the company for breach of contract. The court held that there was a breach of contract. Betul, boleh saman untuk breach of contract, but cannot stop the alteration of constitution. Breach of contract can, yes, can. Okay, so no problem. However, cannot. That's why I said you cannot stop the company from altering their article of association, and you cannot enforce your right. However, if your rights are being affected, you can sue based on other remedies which is being provided by the law of contract. Okay. Furthermore, under Section 39, in the application of doctrine of constructive notice. So meaning for an outsiders, this internal document is not your concern. So this one I explained to you earlier. Alright, so that's why outsiders cannot enforce it. So this constitution is also a contract between members and its directors. So if there is provisions under the Constitution providing so, under which each person agrees to observe the provision of the Constitution so far as they apply to that person. So let's say if there is a provision inside the Constitution with regard to the directors of company, then under that situation, then this also becomes the contract between the directors and also the company. Let's say the directors must own certain amount of share. The Constitution provided is so. Then under that situation, the director need to comply with that. Okay? Because director also is part of the member of the said company. And number 5, this is also a contract between the company and its directors or company secretary. If there is provision, the same. The argument is same like what I stated earlier. If there is provision under the Constitution providing so, under which each person agrees to observe the provision. If there is provision, say a secretary must have certain license or certain certain degree or certain certificate, then of course secretary need to comply with that. Okay? So alteration of the Constitution. So can a Constitution be altered under Section 36 Sub 1 of the Companies Act? It allows the company that have a Constitution to alter or amend its Constitution by a special resolution. I have highlighted in red, unless if the Constitution itself prohibits the alteration or the amendment. If not, they can alter the Constitution, however, through a special resolution. And once it's been amended, of course, under Section 36 Sub 2, the Constitution shall bind the company and the members from the date of passing the special resolution. Yang baru tu, perlebihan special resolution or a later date depends on what is the date stated inside the Constitution. And this Constitution which has been altered need to notify the Registrar of Commissioner of Commission, CCM, and a copy of the Constitution need to be lodged with the CCM within 30 days from the date of special resolution. If the company fails to do that, then the company will be fined 10,000 ringgit and further fined of 5,000 ringgit each day until it is being complied. Okay. When actually the law allows the alteration of the Constitution? First, wanted to alter the company's name, conversion from a limited company to a limited company, conversion from a public company to a private company, alteration of the share capital clause. Okay, this is actually allowed to be altered. So what is the procedure? What is the procedure which is to be followed? Just now I have highlighted to you. Must be through a special resolution. What is a special resolution? A special resolution, according to Section 292 subsection 1, means a resolution of which a notice of not less than 21 days. Notice not less than 21 days can be given and passed by a majority of not less than 75% of the members of the company. Okay? And under Section 292 subsection 5, where a resolution is passed at a meeting, the resolution is not to be considered as a special resolution unless the notice of the meeting includes the text of the resolution. Ini penting ya. Kalau dah luluskan, the text of the resolution is not included and did not state that the resolution is proposed as a special resolution, then it will not become a special resolution. So it must include in the text of the resolution, apa resolution yang nak dibuat tadi, and mesti nyatakan also that this is actually a special resolution. So, under Section 37 Sub 1, what is this? This is a situation when the court can actually alter the Constitution. So let's say it cannot reach the special resolution, right? However, let's say there is an application by a director wanted to alter the resolution. It can file this application to court to amend the Constitution by using the procedure in the Act. Is not suitable, then what they can do, they can go to court. And the court can make an order to alter or amend the Constitution of a company on such terms and conditions as it seems fit. Okay? Can also, the directors or the members also can actually file an application to court. Ini kiranya jalan yang terakhir lah. Ya? So nak dapatkan special resolution ni tak boleh. Tapi nak juga pindah perlembagaan, maka jalan yang terakhir pergilah ke mahkamah. Dia mohon ke mahkamah. Director boleh mohon, member pun boleh buat permohonan lah. Tadi sama juga all this amended constitution, tak kira lah whether it's amended through special resolution or whether it's being amended through court order, kena file lah within 30 days. Okay? Okay. So this alteration, number one, cannot be contrary to the provision of the Companies Act. Okay. If it contradicts with the provision of the Companies Act, then it will not be valid. When it's said to be contradiction. Ini contoh example. Authorize the declaration of dividend whenever it has profit. Distributions. So meaning, if let's say the company wanted to declare dividend, must declare only if there is profit. Only when the company is solvent. Kalau company tu tak ada untung, tak mampu bayar dan nak bankrupt, tak boleh bagi dividend. Cannot also provide in the constitution. And private company also cannot alter the constitution, so that the restrictions is being altered. We know that private company cannot offer their share to public, cannot allot share to public. So these ones, they cannot alter it. To make it legal, cannot. Okay, and cannot require shareholder to acquire or hold additional share in the company more than the number who were held on the date the alteration is made, or increase his liability. This so is found under section 194. The Constitution, number 2, the Constitution also cannot be altered so as to include an illegal clause. This is very clear under section 16, section 2, whereby it states that require company to carry on lawful business. Unlawful business tak boleh, and not to do something that is prejudicial to the public order. Tak boleh memudaratkan kepentingan awam against moral and security of Malaysia. One cannot. And alteration according to restriction by company constitution. If there exists a restriction in the company constitution itself, okay, so meaning the power to amend or to alter the constitution is being restricted by the constitution itself. And there are specific articles which restrict this or which prohibit this. So under that situation, they need to follow the constitution. Let's say in the constitution it said it requires a higher majority. So just now I told you special resolution 75%, right? However, let's say in the constitution it says 100%. Then you need to follow the constitution. Or the constitution said before it can be amended, before it can be altered, it need the consent or approval of certain person. Maybe the approval of JKR, let's say, okay, because this is an engineering company. They need to obtain approval from JKR, or certain particular conditions need to be fulfilled. Under this situation, fulfill that condition. Before it can be altered, the company need to obtain certain license, special license, whatsoever. They need to do that. Okay. So if let's say the alteration is against this, then the alteration is not effective. And the alteration also must be bona fide. Mestilah suci hati for the benefit of the company as a whole. Suci hati untuk kepentingan syarikat secara keseluruhannya. Okay. So not only it must be done through a special resolution, through a court order. The members also, when they vote, they have to vote bona fide for the benefit of the company as a whole. Masa mengundi tu mesti fikirkan, is this bona fide for the benefit of the company as a whole? Adakah ini untuk kepentingan syarikat secara keseluruhannya? And what is meant by this bona fide? Suci hati ni apa maksudnya? So in the case of Allen with a Gold Reef of West Africa Limited, what happens is that this shareholder, he have fully paid shares and partly paid shares, and then he died. Okay. So at the time of his death, his partly paid shares had accumulated areas. Banyaklah tunggakan kan. Dia tak bayar tu, banyak tunggakan dia. Lama-lama dah jadi menimbun, jadi banyak. It can accumulate. So the asset of real estate were insufficient to meet the areas. Aset-aset dia ada, tak cukup untuk bayar tunggakan tersebut. Then the articles give the company a lien over partly paid shares. So the share which have not been paid, that once, okay, the company can actually exercise a lien. Tahan lah share tu yang tak bayar lagi tu. And then what they did, they passed a special resolution whereby they altered their article, the company altered the article now, so that it gave the company a power for a lien over the fully paid shares. So asalnya boleh tahan cuma saham yang tak bayar lagi. Tapi sekarang dipindah perlembagaan yang dah bayar pun diorang nak tahan. So that's why now, siapa yang tak puas hati dalam kes ni, the executors. Pentadbir pusaka tu tak puas hati. The executors of the DZ estate, now they wanted to invalidate mencabar ya pindaan perlembagaan tersebut. However, the court held that alteration was valid. Why the court held the alteration was valid? Court held that the judge said it must be exercised not only in the manner required by the law, but also bona fide for the benefit of the company as a whole, and must not be exceeded. So in this case, actually, dia kata untuk kepentingan syarikat, dan dia kata although yes, in this case directed toward the interest of particular shareholder, however it was bona fide. Tapi suci hati for the benefit of the company as a whole, as the company could recover the money owed to him. That's the only way, right? So yang ini dibenarkan. However, this phrase bona fide in the Green House versus Arden Cinemas, the judge MR said that the expression meant the benefit which any individual hypothetical member of the company would enjoy directly or through the company, and not merely a benefit to the majority of the members only. Okay? The test of good faith does not require proof of actual benefit. It was merely the honest belief on reasonable grounds that benefit would follow from the alteration. So maybe at the moment you cannot see what is the actual benefit you can gain from this alteration. However, later on from the alterations, okay, the benefit will follow. So this is also considered as bona fide. So in the case of Shuttleworth versus Cox Brothers and Company, the Constitution provision appointed a director for life. So inside the Constitution, it appoint this director for life, sepanjang hayat, pelantikan director ini. And then they altered the Constitution, pindah perlembagaan, now enabling this director to be removed upon a written request signed by all other directors, and court held this valid. So director ini dilantik sepanjang hayat, sekarang dia mungkin pindah perlembagaan, membolehkan penyingkirannya, di mana ada permohonan secara betul oleh semua director, dan mahkamah kata sah. Why? Because this is bona fide for the benefit of the company as a whole. Okay. Honors of proof, beban bukti. Siapa yang kena membuktikan yang alteration ini actually is not valid? Okay. So who owes the honors of proof to show that the majority actually did not exercise their power? Shareholders yang seek actually, siapa yang memohon, shareholders who seek that the alteration is invalid, they have to show a proof actually that it is invalid. So in the case of Duffin Template Company Limited versus Lanley Steel, what happened is this. So the company amended the article of association to allow the majority of the shareholders to decide that the shares of any member, except for a certain shareholder, be offered for sale to any person the directors choose. So dia pindah perlembagaan dia, membenarkan pemegang saham majoriti menentukan saham mana-mana member lah, kecuali member tertentu lah, dia ditawarkan untuk dijual, okay, to any person the directors choose. So they can actually, majority shareholder can actually decide whose share actually they want to decide offered for sale, and actually the value will be determined by the directors, and nilainya tentukan oleh directors. Why they do this? This is very harsh. How come you suddenly wanted to acquire people's share, offers his share for sale, and then the price also is to be determined by the director? Okay, but why they do this? Why they do something very harsh like this? You wanted to acquire one of the members' shares and then offered it for sale at the price which is been determined by directors. They did this with motive actually to enable the company to purchase the share of one of their members who had formed a competing company. They wanted to get rid of this shareholder. However, the court held that the alteration gave the company powers which is much more wider than necessary to get rid of this problem shareholder. Okay? The effect of the alteration ultimately gave the company the power to acquire the shares of any other member, even if they did not do anything detrimental to the company. Yes, at the moment, they wanted to get rid of the shareholder. However, at the same time, okay, if later on, suddenly, the company just, a certain shareholder, they feel they don't like the shareholder, they can also exercise this power. Whereas this shareholder did not do something which is detrimental to the company. Apa yang boleh kuasa terlalu besar, Sehingga satu hari nanti, jika ada shareholder yang tidak bersalah tapi tidak disukai, juga boleh disingkirkan dengan cara begini. Ya, sedangkan dia tidak melakukan apa-apa yang memudaratkan syarikat. Tak bolehlah, ya. So, invalid alteration. Why alteration is invalid? Okay. This is our last chapter today under Constitution. Okay, student. Our last chapter today, number 6, invalid alteration. Pindaan yang tak sah. Okay. Alteration of articles, why they are being declared invalid? Kenapa ya diputuskan oleh mahkamah sebagai tidak sah? In most cases, because majority shareholder abuse their powers. Because we know that the vote is through through special resolution whereby 75% vote. Meaning this is the power of the majority shareholder. So where this majority shareholder have abused their powers, court will declare this as invalid. Because why? Because actually this is a fraud actually against the minority shareholder, yeah, and operation, yang merugikan pula shareholder minority. So let us have a look in the case of Brown vs. Abrasive Wheel Company. So 90% of the shareholders altered the articles to allow the majority to get rid of the small minority. Kesian kan? Ya. 90% dia mengundi, dia nak menyingkirkan minority shareholder. So that they could subscribe for more capital. Because they wanted to subscribe for more capital that the company badly needed. This was held by the court as what? As it constitutes an abuse of power and fraud on the minority. So this is not allowed. Okay. Thank you, class. That's all for today. Okay. Under the topic of Constitution. Until I see you again next time. Bye-bye, class.